Hello and welcome to the Srijan Wednesday webinars. First up, a very happy new year to all our attendees today, and we are kicking off our 2018 webinar season with a session on the European Union's General Data Protection Regulations. Today, for today's session, we have Matt Skinner with us, who is the head of digital strategy at Proctor and Stevenson. Matt and his team are working very hard to make their clients help their clients understand what GDPR is and how they can get their businesses and their practices compliant with GDPR. And Matt is going to be doing the same for us today on this session. So without wasting any more time, let's get right to it. Matt, over to you.
Okay, hello everyone. My name is Matt Skinner. I'm the head of digital strategy and data at Proctor and Stevenson. We are in the UK, one of the UK's largest independent comms and systems agencies. We're a Drupal house in Bristol. We do everything from systems build all the way through to marketing and comms. Anything that you need, really, you can think of in that area. We're there: advertising, marketing, communications. Okay, so just to give you an idea of who we are, here are a few of our clients. We work with a number of clients globally. Only about 25% of our business is inside the UK. The rest is global. We work with companies like Panasonic and Daikin. We're the main European agency for Panasonic across Europe. So got a good pedigree. We've been going about 35 years. My job should be to be a chief strategist. So I lead mainly advertising and marketing strategies across our clients. But because part of my job is to do with data, something that I've been working on very closely over the last 18 months is the General Data Protection Regulation, which is what we're going to be discussing today. Now, I understand that we have an international audience here. The reason why we're discussing this is that GDPR, while it is a European legislation, it has an impact globally. I'll take you through a brief introduction, then the main bulk of this presentation is talking about the impact this is going to have on the industry for systems, marketing, and comms going forward. So for those of you that don't know, GDPR stands for the General Data Protection Regulation. So it's a regulation to strengthen and unify data protection for individuals within the European Union. Impacts the collection, processing, and profiling of personal data. Will impact businesses globally. So when we get into the details, the idea is that it's to protect the personal data of an individual, but it doesn't matter where that data is held. If it's to do with a European citizen and you're doing business in Europe, the data you hold will need to be GDPR compliant. This will affect businesses who operate multinationally. It will also affect third parties like agencies who are working with companies in Europe. So it was approved in May 2016 and it comes into force on the 25th of May 2018. Unfortunately, there are still kind of updates and clarifications going on GDPR, so we don't have clarity on some of the issues. It can be a bit confusing at times for people. If any of you are working with it, I can understand if you're a bit confused by it. So we'll start off some key definitions that we'll be talking about here. So we've got personal data, which is any information relating to an identified or identifiable natural person. I will define in a second exactly what personal data means in the context of GDPR, because it's slightly different to what you think it might mean. Data controller is the person or entity which determines the purpose of the data. So it means that the master company. So if you had a client, an agency relationship, our client is Panasonic. They are the data controller. We operate on behalf of Panasonic, so we are the data processor. And then there's processing, which is any operation which is performed upon personal data. So anything that happens to the data once you hold it, that's processing. If we say processing, it just means anything that we're doing with it. So the aims of GDPR is to put individuals within the European Union back in control of their data, create a balance of power between businesses and customers. So the idea is that businesses can't take advantage or mislead a customer in order to use their data, to promote transparency so everyone has an idea of what's happening with their data, what's being used for, why it's being used, to harmonize data protection laws across the EU. Now, Across the EU, different countries have multiple laws. Some are very stringent, some are very lax. So across the European Union, they need to be harmonized. Something I will say about this is a question that might come up is if you're operating in the UK, will Brexit affect this because it's to do with the European Union? The answer is no. If anything, it might get more stringent here, perhaps. If you think about how connected the UK is with Europe in terms of how we do business, we're going to have to comply with this no matter what's happening. So yes, Brexit will not make a difference. And it's to make data laws fit for the digital age. So when the Data Protection Act came in about 20 years ago, it didn't take into account a lot of the stuff that we're doing within the industry at the moment. So just to define what personal data is, this is what GDPR relates to. So it's anything that identifies an individual. You don't just need a name. So the examples we've got here are full name, a job title, an email address, direct phone number, data relating to an individual's actions or behaviors. That's quite vague, but it is vague. If you've got any information about an individual and you're looking at what they're doing, GDPR applies to it. So web analytics, that kind of thing. And a computer's IP address, which is the most interesting one, particularly for the work that we do in systems and comms. So if someone comes to a site, their IP address is as good as a name. When we're looking at what they're doing on a website, we're identifying or profiling an individual. Any data held on an EU or UK citizen will need to comply. Now, that's actually misleading. I apologize for that. It's not a UK citizen. It's someone, or EU citizen, it's someone within the Eurozone. So if you are, say, British and or Welsh and you live in India, for example, and you're doing business or using Indian services, that does not mean this applies to you. You can try, but it doesn't mean it applies to you. So you would need to, the GDPR doesn't apply to you if you're European in any country. It's about doing business within Europe. At the same time, if an Indian citizen was in Europe and they were using European services, it would apply to them too. Data on EU systems will be treated the same wherever it's held. So if you're international, you need to store data relating to business in the EU or personal data of people, subjects in the EU. You have to comply with this. Okay, so the usage of personal data. So the personal data you hold must be fair and lawfully processed for limited specified purposes. I will go into this in a bit more detail. It's just to give you an idea. Given the purpose of the processing, data must be adequate, relevant, and not excessive. The idea of this is that you collect what you need in order to perform the function that the end user has agreed will happen. When we get onto the part about comms, it will show you a bit more of an example of what this actually means. It can be kept for no longer than is necessary in order for the purpose of you're using it, and it needs to be secure. Key thing to remember here, and again, when we get onto comms, there'll be an example of this. Data controllers, so companies that own the data, are responsible for demonstrating compliance with these principles. So if you are sending someone an email, which is the example we'll come on to later, if you're sending someone an email, you must be able to prove that that person has consented to receive that email. That's very important. So shortly we'll come on to the legal grounds of how you can process someone's data under GDPR. Email generally is consent. So if you are using consent, you need to be able to prove that that's happened. Otherwise, you don't have it. That's very important when we talk about how you store information and what systems you need in place in order to do this. Punishments. So if you breach GDPR, this applies to both the data controllers, it applies to data processors, no matter where you are. So if an agency like us process something on behalf of a client and it breached GDPR, we would also, sanctions you've got here are a warning in writing in cases of first or non-intentional non-compliance, regular periodic data protection audits, and then we get into the big one. So a fine of up to 10 million euros or 2% of the annual worldwide turnover of the preceding financial year for an enterprise, or the big one is a fine of up to 20 million euros or 4% of the annual worldwide turnover. Now, if you think about a third party, you think about an agency like us, If we process something on behalf of Panasonic and they got this fine, it would be devastating to Panasonic, but it would wipe us out. So it's very, very important, no matter the size of your company, that you are compliant with GDPR. Otherwise, you're probably out of business, unfortunately. So here this is a snippet from a slide that we'll show later, but these are the legal grounds for processing data. There's consent, which means that the data subject has consented directly to the processing of their data. There's contractual grounds, so the data is being processed in the performance of a contract. Legal grounds, so if someone is on trial or there's a legal reason why someone's data needs to be processed, it can. Vital interest, which is, say, someone dying and they're in A&E and you need to be able to access their medical records, but you've got no other way of accessing them, that's fine. So you can do that. Now, obviously, that doesn't apply to communications, which is what we're talking about here. There's going to be at no point that someone is going to be on their deathbed and you need to be able to send them an email, for example, but it's good to know. Public interest means that this is kind of the get out of jail free card for governments and the police and that kind of thing. If there is a interest for the public in order for the data of an individual to be processed, it can. Legitimate interest. Now, this is the gray area. This is when we come on to comms, we will look at how legitimate interest is used and being misunderstood. So the three that relate to comms and marketing and systems generally are legitimate interest, consent, and contractual grounds. We'll come on to those again shortly. So security, so this is important for your systems. Now, there is no kind of standard for security. I mean, you could be operating and holding client data in just spreadsheets, but you just have to make sure those spreadsheets are secure. There's an obligation to keep the data secure. So, for example, secure use of staff equipment and IT systems. So making sure that if personal data is held on a laptop or something, that there is a procedure in place to make sure that that data is stored safely. Encryption processes. Now, I'm not a data security technical expert, more about the theory and the comms side of things, but the encryption that we use for data that is stored within servers, for example, is important. Clear desk policy, so not printing stuff out, not having stuff lying around, that all counts as personal data. You've got names and addresses on desks, this sort of thing. Who knows where that could go or what it could be used for. You must understand the confidentiality obligations of the information you hold, and they must be respected. And then there's a transfer of data between a controller and processor. I'll give you an example of this. We do email campaigns for clients. Now, often we get spreadsheets. Something that we're implementing here is that if a client is sending us a spreadsheet of information, it gets transferred on something like a share file. We download it, we use it, we delete the spreadsheets. What we will likely do going forward is that we will refuse to take spreadsheets from clients. It just makes more sense for the safety of the personal data that we're using. But all of these kind of things need to be thought about. Third parties, this is important. So if you're a third party, you're an agency, or you are a company using an agency, for example, you need to enter into a written agreement with them, a data protection agreement that lists out exactly what you want to do with the information, what you want them to do with the information you're processing. So you must make the third party aware of your expectations and requirements. This is important. If any third party tells you that they can make you GDPR compliant, they are lying to you. They can't do it. Companies like us, we can assist your processes, but if you do need to become GDPR compliant, this is something that needs to come from within the company. Excuse me. It needs to be something that comes up from within the company. It is not a system that is going to cause a breach of GDPR or a process that's going to cause the breach of GDPR. It is the misuse of a system or the misuse of a process. So it's important that there's education and there's responsibility taken within an organization. If you use a third party who is not up to date and up to speed with GDPR compliance and doesn't understand what they're doing, it puts you at risk as a company. If you are a third party and you are processing data on behalf of a client who doesn't understand GDPR, it puts your business at risk, and it also puts all of your other clients at risk. If you process some information and breach GDPR and you receive a 20 million euro fine, that means that you're out of business or your clients lose their agency. This is particularly if you are outsourcing and you're based in a different country. This might be something that European companies look at. In India, for example, the UK outsources a lot of work to India, particularly in terms of web builds. It is something that will be considered. There will be a consideration with, will this be GDPR compliant if it is built or managed in a different country outside of the European Union. So it's important that if you do build and manage comms processes for European clients, that you are up to date, up to speed, and you know how to talk to them about GDPR. It's chaos here at the moment. I'll explain a bit more in a second, with companies not really understanding what they're doing. So it's important that you as a third-party provider do. So just a quick slide to show you the impact this is going to have on comms and marketing. So you've got acquisition, you've got your website, and you've got the database. Anything in pink there will be affected by GDPR. So the channels where someone comes to a website, direct digital advertising, email, this will all be affected. Social may be to a certain extent. You've got everything that happens on the website, so you've got a conversion point. You need to have certain consent boxes, which we'll show in a moment. Your analytics tools, you may need new disclaimers on the site because of your analytics. If you're capturing or profiling someone using an analytics tool, they'll need to be aware that that's happening. And personalization, so using data to personalize the experience for any customer you are profiling at that point. Then within the database, you've got anyone with an explicit opt-in, and it's GDPR compliant opt-in, that's fine. You can email them. If you've got a bought-in list, they'll be gone. You can't use bought-in lists anymore. Something important to remember about GDPR is that any data that is not GDPR compliant by the 25th of May will need to be deleted from any system. You cannot keep it historical data. If it's GDPR compliant, it's GDPR compliant. There's no leeway. This means that list brokers, which we'll talk about in a second, list brokers will become pretty much obsolete, we think. Your existing customers, you'll need to get consent in place for them for certain types of comms. And exhibitions, or we should say offline, so anyone you meet offline who agrees or consents to receive marketing communications from you, you're going to need to have a process in place for making sure that consent is recorded. And I'll show you an example of this shortly. So I'm going to jump onto a different type of presentation now, which is something that I take people through here. In fact, we're doing a big event tomorrow that I am taking people through in this, which is talking about comms in particular, how comms works, and what the issues are going to be within the industry when it comes to this sort of thing. Okay, so impact on comms and marketing. Okay, so broadly, we're looking at data harvesting, which is what we do as an industry. Data harvesting will become impossible. Marketing databases will become smaller, but their value will increase. Volume is a big issue that we'll discuss in a moment. List brokers, as I've said, will become near obsolete. And the way data is collected generally will need to change. So conditional incentivized provisions mean that marketing strategies will become riskier. There's one in particular, which is just a theory of mine, which we talk about in here, that I think that we do as an industry. I believe that this is, in fact, in breach of GDPR, if you read it this way, at the extreme end. So this is what it should look like. This is what GDPR should look like to everyone in our industry. It's fantastic. We've got a situation where we have to make sure that the people that are in our databases are really happy to receive our data. We get to do great advertising campaigns. We get to do great creative, really excite people. Unfortunately, people are reacting like this. So they're trying to run away scared as fast as possible because this is absolutely terrifying. Now, we've got this issue of how we use marketing databases as an industry. So on this slide here, you'll see that you've got all the ways roughly someone can enter a marketing database. So you've got a manual addition, someone just jumps in, enters someone's details in, they're in the system. You've got people filling in forms on websites, you've got bought-in lists, and then you've got customers or prospects from the CRM. So they're pumped into the marketing database where they're held indefinitely, and then we just send communications to them. No matter, just keep going. There's no real segmentation. Some people do some segmentation, but there's no real feeling of what we're sending or why. Generally, as an industry, I know it's different from company to company, but we tend to just plow people with information. The issue with this, and the reason this is happening, and the reason GDPR is an issue within the marketing and comms arena is because of volume. It's a leftover from the days of print advertising, where the number of people who saw adverts or the number of people that walked past something, that was a measurement of how well something succeeded. So we're obsessed with volume as an industry. We're obsessed with the number of people in our database. Now, what's interesting is if you look at how we deal with things like, in particular, emails. So we'll send an email out and we will celebrate open rates of 20%, for example. Get rid of that. I apologize. We'll celebrate open rates of about 20%. Now, if we were putting together an advertising campaign as an industry, would any of us advertise a product saying 2 out of 10 people approve of this product? It's nonsense. Something needs to be done, and GDPR is a big step in the right direction to allow us as an industry to succeed, to finally do the things that we wanted to do when we got into this industry in the first place. So this is an example of a client database that I work with. Almost 200,000 people in that database. Only about 30,000 have opened an email in the last 6 months. What's even more concerning is if you look at the number of people who've clicked on those emails, 3,646, which means that 98% of the contacts in that database have never clicked on an email. If you look at the way that this company performs in their database, you can see that actually they're doing fine in comparison to other users. The issue there is the number of reachable contacts in their system. Now, it doesn't seem to be a problem with creative, because the creative and campaign management are generally quite good. Now, we've got our legal grounds here. And we've got legitimate interest, consent, and contractual grounds, which are mainly to do with comms. Now, legitimate interest and contractual grounds are used. The problem that we've got in the industry at the moment is that a lot of people are approaching GDPR, particularly with comms, as saying that legitimate interest and contractual grounds, how can we use them to avoid consent? So, can I use legitimate interest? Now, legitimate interest, what that means is if there's a balance of interest between the data subject and the data controller, you can process that data. So a lot of people are seeing that as an example of saying, okay, so my potential customer likes computers, so I have computers to sell so they can contact them. That's not how legitimate interest works. Legitimate interest works with if you were to go to a trade show and you were to meet someone and someone were to say yes to receiving your marketing communications, they're consenting verbally. Now, verbal consent is valid, but you cannot record it. So what you need to do in that instance, an example we'll show in a moment, is make sure that you have some sort of autoresponder that goes out to the client that says, hey, we met you, we know you're happy to consent to receive marketing communications, could you just click here to confirm your subscription? Now, that email is sent under legitimate interest grounds. So they have said yes, there is a legitimate interest for you to contact them. It doesn't mean that if you think they are legitimately interested in your product, you can send them marketing communications. The other one here is contractual grounds. You can contact customers with information about products that relate to the product or service that they are they're currently buying from you. So if you, and we'll stick with the laptop analogy, you've got a laptop, there is an upgrade to the software on that laptop that they have, or there's a fault and you need to contact them about them. Those are processed under contractual grounds. It doesn't mean that they're our customers, so we can just bombard them with marketing information. So the question the industry is asking at the moment across Europe is, how do I continue to avoid relying on consent? What we're saying is, and the best way to prepare for GDPR is, how do you only rely on consent? Once you get into that mind space, everything kind of clicks into place. The number one issue here is, if your marketing communications are not worth saying yes to, you have a problem with your marketing communications. You do not have a problem with GDPR. So what is consent? So consent is freely given, specific, informed, and unambiguous. So it needs to be clear and plain. If you're talking about emails in a tick box, that sentence, you need to explain exactly what it is they're going to receive and exactly what they're consenting to. Clear affirmative action by data subject, so don't have a pre-tick box. It needs to be recorded so you can demonstrate when consent was given, as we've discussed. When in writing, it needs to be distinguished from other matters, and if you're dealing with children in any way, it needs to be authorized by parent or not at all. So consent needs to be easily withdrawn at any time. The line they're using is that consent needs to be as easy to withdraw as it is to give. So unsubscribe options, preference centers, that kind of thing are very important. Okay, consent cannot be a contractual requirement unless necessary for performing the contract. So the example there we've given about contractual, it can't be conditional on anything else. So it can't be tied to something else, and it can't be the default, as we've said. So consent needs to be specific, informed, and unambiguous, as we said. The period of retention must be made clear somewhere. Now, if you're using this for email communications, then generally what we're saying is that 24 months, make sure your database is refreshed. You make sure that people are still opted in, they want to receive your information. But this needs to be judged, all of this needs to be judged on a case-by-case basis. And you must not collect any more data than is necessary for the process. So if you're sending someone an email and they're subscribing to a newsletter, really, under most circumstances, you don't need more than their name and their email address in order for them to continue to receive that email. We don't need to be collecting or harvesting data about someone, which we're using to profile them. They just want to receive an email. So here's an example of a tactic that we all use in the industry that this is personally, I think that we're going to have issues with this with GDPR. So this is a white paper download page. So if you look at the white paper download page, the user journey is someone has come to this page and we've advertised this white paper saying, do you want to have this white paper? Yes, please. I would love this white paper. They come to the landing page, and to the right of the page there, we're saying, yes, okay, well, if you download the white paper, give us all your details, and then tick the box at the bottom. And the box at the bottom says, if you receive this white paper, we'll also send you a bunch of emails, just hidden down at the bottom, which is no good. We are tricking people into giving us their information. This is an issue that we have in the industry across the board, in that we don't believe that people want to receive the emails, or the emails are not good enough. So there's no point. Let's trick them, and then we can bombard them with emails. So we need to shift the audience mindset from I don't object to receiving marketing communications to I want marketing communications. Easier said than done, but this is really what GDPR is asking us to do in comms. So if you remember this from earlier, we've got this database, 200,000, 188,000 in the database, 3,500 have clicked through from the email in the last 6 months. This is an example of another client database where they've got 12,000 people in that database. 4,117 have clicked from an email in the last 6 months. The difference between these two databases is this one is based on a consent mechanism, or primarily based on a consent mechanism. Now, it's interesting to see that there are considerably less people in this database, but the pure number of people who are engaging with that content is higher than the database with 200,000 in it. Something that's worth noting is that in the previous database, each data subject in that database has a value assigned to it. So within the marketing pipeline, all of those 188,887 have a value assigned to them. Now, most of them don't have consent that we need for GDPR. So on May the 25th, most of those need to be deleted. Now, they're not losing anything, but senior managers will be losing something because their pipeline will completely drop off the cliff. They'll lose hundreds of millions in pipeline. Whereas this database, very clean, very tidy, probably could do better under GDPR. Some of this stuff in here, these 12,000 contacts, are from bought-in lists, but you can see the difference between the two. So we're saying treat your comm strategy as a new service line, a separate standalone subscription service. Manage it as such. What do you want to know when you subscribe to something? What am I subscribing to? How long am I subscribed for? How do I unsubscribe? This is how a comms strategy should be managed from May the 25th if you're dealing with European customers. Utilize your existing systems and channels to promote this service. So you won't be able to buy in lists anymore, so your databases are going to shrink. How do you do this? Now, this is the point at which we really do have to connect the marketing, comms, and systems part of the business with the rest of the business. So receptionists, salespeople, account handlers, anyone you've got there. So at every point you speak to or contact a customer, include an option to gain consent. So here's an example for an offline service. So you've got here a little process that we're talking about. If you meet the example I gave earlier of a trade show, so prospect and a company representative speak, consents obtained verbally. The representative then gets their details, goes back to the office, puts their details in the CRM. The CRM tells the marketing database that consent has been given by the contact. The marketing database generates an autoresponder confirmation email to the prospect. The prospect confirms their subscription, and a record of consent is stored in the database. At this point, you've gone through the process. This seems to be legally sound. You've got the consent on record. You've got everything in place, GDPR compliant. But try and do this if you're advising customers, you're doing it yourselves. Try and think strategically about the long-term implications of this, that you will need to gain consent, or it is best to gain consent from everyone that you want to contact. So we've got this. Remember, this is how users currently enter databases. This is how we think they should. So they can only enter a marketing database in one of two ways, either through the website or through the CRM. Nothing else goes in there. In your CRM, you've got the consent or legal grounds are recorded. They're passed into the database. They come from the website. They're in the marketing database. Make sure that we've got the right consent on record. Then we send communications, or the relevant communications, depending on what they've consented to. So here's an example of the information you should have on file. You've got my name. I'm interested in Care Bears and data regulations. I have requested communications on events, newsletters, and guides. My language is English. I subscribed on the 12th of October at 6:47, which means that my subscription ends on the 12th of October 2019. Maybe 3 months before that subscription ends, with the marketing automation database that I'm using, I generate a response that says your subscription is coming to an end. If you're still happy to receive these emails, please reconsent. So you can send information to me about events, offers, or product updates related to Care Bears and data regulations for 24 months. So in summary, and I'll cover some ground quickly here, GDPR is an opportunity. It's not a threat. It is great for the industry. It's great for the entrepreneurial members of the audience here who are thinking about ways that you can maybe have new avenues into Europe, or if you're in Europe at the moment, how to get ahead of the curve so that your databases and your comms strategies are being built at an adequate level. Once this comes into force and the fines start coming out and everyone starts adjusting very quickly, it's a big opportunity. You need to take responsibility as an individual within your company if this is something that affects you, not as a department or not as a business, or pass it on to a third party. This is all down to the individuals within the company. Start from consent and work backwards when you are dealing with comms in particular. Respect your audience. This is what this is about. You need to respect the people who are listening to you. Make sure that the balance of power is there, that they are aware of what they're going to receive and they're happy to receive it. And start experimenting. Have a bit of fun with this. This is finally, any of you that work in comms, or you work in advertising, this is finally a chance to stop taking shortcuts and do the things that we wanted to do when we got into this industry in the first place. Great creative, really exciting advertising campaigns. We can get in front of people in the right way. When the playing field is leveled in advertising, it always comes back to two things: who has the best creative, or who has the most money. This is something that is leveling the playing field. So make sure your creative is excellent. So what we want to do is we want to get people in the industry away from this, and we want to get them to this. So thank you for listening. This is me, and if you want to contact me, these are my details. And if you have any questions, I'd be happy to take them.
Okay. Thank you, Matt, for taking us through that very interesting and very detailed presentation. So, as far as we've gotten to understand it, of course, a lot of companies are, right now on their toes trying to understand what is going to happen to all of their databases, and
Yeah.
how, and starting to look for sort of get around the rules, sort of, as you pointed out in your presentation. But what you're saying is that we need to change the mindset and think that GDPR is actually going to be a good thing for us, and sort of get on board and start from there. Um, while I would request all our participants that if you have any questions for Matt, you can just type them in and I'll take them up with Matt. While you do that, I've already got a couple of questions here, so which I would like to sort of get Matt's views on. So, one thing that you mentioned in your presentation was the analytics bit, as in sort of the entire analytics depends on profiling the people who visit your website. So can you go into a little bit more detail of how is it going to impact our current analytics practices, and what can we do to make those practices sort of compliant to GDPR?
Yeah, that's. I thought that question would come up. That's something that isn't completely clear yet. Now, what we thought would happen is that because you're profiling people's information when someone is using an analytics tool, that you would need to have direct consent in order to pass a cookie onto someone's machine to track them on the website. Now, there are certain, we would say that the best practice is to do that, to have a pop-up come up, and you've got a disclaimer that says, we are putting these details on your machine. Are you happy for us to do that? There are some circumstances. You can look at actually Motorola's website. I think the UK website has already started doing this. And one of the things that's going to be important with this is if this actually is the case, because there is an argument that it's not the case. If you look at the legitimate interest guidance in more detail, which is where this gets complicated, there is mention that a certain amount of web analytics are acceptable. What I would say is preparing for GDPR, go right to the extreme end at first, and then see how it goes, and then you can loosen up afterwards. I would have a cookie disclaimer on the site with opt-ins. One of the again, when I come back to creative, one of the things with this is going to be how do you make it advantageous for someone to say yes to have tracking deployed on their machine. What is it that you're giving them? Now, there's a misconception about the advertising industry that what we're doing, especially digitally, is somehow kind of nefarious, where we are monitoring people, or we're tracking them, or we're telling them what to do, or we're finding stuff out about them, which isn't actually true, really. It's we are trying to learn about our customers in order to give them a better experience. If we give them a better experience, they will end up buying more products. Now, we're not going to do anything to them that's harmful. It's just the way that we position these cookies that's important.
Okay, all right. So you're saying one of the better practices would be to sort of have these notifications, or sort of inform your customers and website visitors that this is what you're going to be doing, and
Yeah.
then move forward from there, as you said. Okay, so also we have a couple of sort of interesting use cases. I mean, questions around a couple of interesting use cases that are sort of coming up. One of them is
Okay.
that if you are a company operating that operates that operates outside EU,
Yeah.
but you sort of have a so right now you have a database of people, and you have clients who are in the EU, or you have prospects in the EU. So so this company has to start to think of becoming GDPR compliant, because no matter where they're operating from, if they have business in EU, they will have to start sort of thinking about GDPR, correct?
Yes, that is right. So if you are Example I'd give is if you are a company like yourselves, for example, if you are operating globally but you're based in a non-European country, if you are dealing with European customers or prospects or clients, their data will need to be held in a GDPR compliant manner. It doesn't matter where the data is. If it applies to a European subject, then it is you are potentially looking at a fine if you breach this.
Okay, all right. Another question that we have got is that the GDPR that's coming into effect, is it also going to impact data that has been held with the company, let's say, for over 10 years now?
Yes, it's this rule is very clear. So if your data that you hold is not GDPR compliant by May the 25th, 2018, it is not GDPR compliant and it needs to be removed. There are no historical provisions. You need to make sure everything that you hold, for example, if it was in an email comms database, you have to make sure that all the consent that you have in there is GDPR compliant consent. If it's not, you need to delete it.
Okay, understood. So, for a lot of companies that have built sort of huge databases, let's say they had a sort of opt-in procedure to start off with. So they just, let's say they had a simple opt-in procedure that they get a mail and they click on a link that says, that sort of implies that yes, you have opted into this thing, or to be a part of this list or receive certain communications. So is that GDPR compliant, or does that have to be a little more specific in some way?
Could you repeat that?
Yeah, so I'm saying, let's say a company had a sort of opt-in procedure for all of their communications. So somebody
Yeah.
signs up for something and they get a mail that says if you could just click on here to confirm your subscription or something like that. So so does that count as written GDPR compliant consent, or does it have to be something more than that?
No, it's the as long as the problem with GDPR at the moment and the way that it's being interpreted is that there's no kind of set of rules. You just have to meet certain conditions and make sure that if tested, you can make a reasonable, justified argument that you are compliant. So with consent, there's no. What we would suggest is that you always go with a double opt-in. You would go with this. You need to record. You need to have certain things on file. If we skip backwards on this, and I can show you this. So if we skip backwards and we look at the information that you should have on file. Now, we think this is good. This is GDPR compliant. So you can show all of the information on here. If anyone challenges you, you know when someone consented. You know when the subscription ends. You know the type of communications that they have directly requested. You have the consent on record. You need to just make sure that you've got everything in place that will prove it. Now, different legal departments from different companies are saying different things about what this actually means. But there's no kind of hard and fast list. It really does have to come from within, and you need to understand the legislation.
Okay, okay, all right. So, Matt, as an agency, right now, I mean, I'm pretty sure a lot of our audiences are these agencies who are data handlers or data
Yeah.
processors for different companies. So, and you're saying a lot of the databases have to be clean, and the marketing messaging and all of that has to become better so that people actually want to opt in. Now, on the point of the databases having to be deleted, how easy or difficult are you finding it to get your clients on board with the idea that a lot of the database that has been deleted eventually has to go off now post May 25th?
It is extremely now. A lot of clients understand this will be an issue, but I think that the big thing that we're noticing, I wrote an article about this last week actually, which is that there seems to be a lot of denial at the moment that this is actually happening and it's going to cause an issue. Now, people are aware that this is going to be a gigantic issue moving forward, but they're not really doing much about it. So they're not trying to. Um, they're thinking about things that they can do, but there's very few that have actions in place. I mean, I personally haven't received many emails from any company telling me to upgrade my consent for even things that I've consented for. There there isn't so much a hesitance to do it. I think that there is the penny hasn't dropped yet that this is what's going to happen. Um, it's the next few months and the few months after May are probably going to be quite chaotic with people starting to panic about doing this. So I wouldn't say there's hesitance. I think that there is the understanding just isn't there yet.
Okay, and for agencies that are sort of trying to get their clients on board with this change in processes and change in practices, what do you think is a good way to sort of get your clients on board, or to make them understand the sort of impact it's going to have on their business, let's say? I mean, what is the best way to do it to make them understand this
Yeah.
is what how we have to.
I would say be proactive and be aggressive with it. I started working with GDPR on GDPR about 18 months ago, and it was people. No one really paid much attention at first. Now, my job was to understand the legislation at first, understand the implication, kind of chart and map where this will take the industry, and it became very apparent to me very, very quickly that this is going to be a significant issue within our industry. Now, what happened, or what has happened, is that bringing it up repeatedly with the clients over the last 18 months, and as the awareness in Europe has grown around this, our name, or myself and Proctors, have been in front of the clients as and when this has come up. And when they've been ready, they panicked. The GDPR has popped into their head, and they said, "Well, Matt at Proctor's and Proctor and Stevenson spoke about this. I'll go and ask them for advice." Now, as I said, we can't make anyone GDPR compliant, but we have a wealth of experience and understanding of how it works here. So, I think the key thing is, if you're a third party providing services to European customers, I would say educate yourself, bury yourself in this for the next few months, and make sure you are asking your clients proactively about their plans for this. It will give them reassurance that you are thinking about it. Now, you need to deliver on what you say, but make sure you bring it up first so that they don't go elsewhere to try and find information. Make sure that they have the reassurance that you will be prepared for it.
Okay, that's actually some great advice. So one of the last questions that I've got here is that in terms of in terms of, you spoke about how GDPR could be sort of an opportunity for the marketing teams to sort of do the kind
Yeah,
of work that they wanted to do and make sort of more creative, more sort of better campaigns that people actually want to listen about or hear from. So in
yeah,
similar vein, are there some other opportunities that enterprises could be looking at once they become GDPR compliant? I think that would be sort of something that they would have to look forward to, other than fear, uh, to sort of get them on their feet to sort of become.
yeah. I think this comes back. I think it's a lot of this is a lot of GDPR is, and the reason I've concentrated in comms is a lot of the worry at the moment is around how we use emails, and the issue, as I've said here, is that people are trying to find ways around it rather than confronting it head on. I think in the midterm, what we're looking at is email remaining central, and most companies trying to find ways of generating a larger email database. What I think is probably going to happen is the reliance on email is going to dwindle over time once it becomes apparent that just pumping unsolicited emails out from a database is not going to be possible anymore, and your database size will shrink. I think what will likely happen is that we'll be looking at, particularly online, a much bigger push over onto social. I think that social it's a database away from your database. So someone following or liking is going to be a lot easier an action to provoke than it is to get someone to part with their information. Now, if we use social in the right way, and we are setting up social feeds in an entertaining, exciting, informative way for our audience, this is a great opportunity to actually generate content that clicks with people. Digital's not dying because of this. I just think that it's shifting. My perspective on this is that this is the moment where the digital marketing industry kind of steps into the sun. We stop trying to cheat our way around the system, and we just start trying to produce good work.
I think that's some really good food for thought for a lot of digital marketing folks out there. And I think yeah, that's a really good note to end our session for today. I think that's all the questions that we've had from our attendees today. And once again, thank you, Matt, for leading us through the very interesting presentation. And I'd like to thank all our attendees for joining us today on the webinar. And please stay tuned for our future webinars. And once again, thank you all for joining us. That's all for today.
Thank you.
Thank you.